Hello everybody, welcome to our webinar on the National Security Investment Act. I'm David Lowe, I'm one of the organisers of Think House, and I'm joined today by Sam Baton, a partner in our antitrust team. This is a webinar. It is also recorded and you'll have the opportunity to get the link for the recording afterwards. It will last no longer than an hour. If you have any questions as we go along, just pop them into the Q&A and I will pick and select some at the end to first ask Sam. Obviously this is a webinar, but we will be doing a physical Think House and a real life Think House in the end of March about supply chain, traditional format of our half day for our big event. So do look out for those invites. We'll be issuing those invites during the course of next month. So National Security and Investment Act, it's hardly the kind of dinner table conversation, is it? It's the kind of thing that your children will definitely glaze over if you were to mention you're watching a webinar on the National Security and Investment Act, but it is important. I mean, to date, the UK government has traditionally very limited opportunities to intervene on M&A activity, asset purchases and so forth. It's quite a high bar for it to have previously intervened. And that's different to other jurisdictions. If you look at the states, for example, they've got very wide powers for the government to intervene on transactions. And so to some extent, this legislation, you could say, is catching up with other jurisdictions. But it does change our attitude in the UK. And previously, we didn't traditionally have to worry that we're buying a big piece of kit or piece of land or buying a company, whether we needed to go and tell somebody about it, unless there was an antitrust issue. Or you're in certain very specific areas. But that has now all changed, and we think you as in-house lawyers will be more frequently asked, do I need to worry about this? And you certainly should be at board level flagging where transactions may be at risk of being subject to this legislation. So without further ado, I'm going to hand over now to Sam, who will take us through it.
Thanks, David. And I think, to my mind, the purpose of the session today is really just to try and give some comfort, some pointers as to the key issues, key risks to be aware of. And what I wanted to cover in this context was just thinking about, firstly, what does the NSI Act actually change? And what transactions can now be reviewed? How can transactions be reviewed in this context? What's the impact of this new regime on transaction timing? How does the NSI regime interact with the UK merger control regime? That's the fact I think people do need to bear in mind as they think about how transactions are being done, the risks arising. And when we are talking about and thinking about risks, the bottom line essentially is how can these related risks be managed in this new world that we have? What steps can be taken to manage these risks that have been identified? So to begin with, by way of an overview, what we have is the NSI Act, which was enacted in April of 2021 and entered into full force in January of this year. So there is a bit of a time lag there. And in that intervening period, what we have seen are various statutory instruments that have been put into force. And what those do is provide extra detail around aspects of the Act and also put in place some of the framework that's required for the Act to actually work on the ground in terms of a practical piece of legislation. And what the Act does, it introduces a UK regime, and what this UK regime enables is the screening of transactions on national security grounds. Now, before the NSI Act, as David mentioned, the issues around national security, those were addressed under the UK merger control regime. What we now have is a situation where the national security grounds have in effect been excised from the UK merger control regime. They've been packaged up, some more bits added to them, and they are now addressed under the NSI Act. And what we now then have is the NSI regime existing in addition to the UK merger control regime. So NSI is not a one-stop shop. This is another regime that parties need to think about and engage with when they are planning transactions. So in terms of who is responsible for the regime is managed by the Investment Security Unit, the ISU at BEIS, and the Secretary of State is the decision maker. what we will see is that a range of transactions are capable of being reviewed under the regime, and the regime has deliberately broad application. I've just picked out a couple of areas here to flag, and we will touch on these as we go through. But potentially falling within the scope of the NSI regime are transactions that involve only UK entities and assets. Now that is different to a number of other regimes worldwide that focus upon foreign direct investment. The UK regime is agnostic in that context, and transactions that are just UK to UK, those could be caught by the regime. Also, I think this is a point that's worth flagging, because I think that this perhaps hasn't received some of the publicity that other aspects of the regime has, and that is that corporate restructuring or reorganisation activities within the same group could nevertheless be caught by the NSI regime. There is no de minimis thresholds, there's no minimum deal value or transaction value. If the various criteria are satisfied, and that is sufficient for the act to be applicable. There is the possibility of retrospective review. So certain transactions that completed between the 12th of November 2020 and the 3rd of January this year could potentially be reviewed. And one really big difference, which I think we will all be aware of, is we now have a mandatory notification requirement, and that is applicable for transactions that we're completing from the 4th of January. What that does is that addresses certain transactions that affect 17 high-risk areas of the UK economy. And where you have transactions that are addressing those areas, they must be approved by the Secretary of State before being completed. And that is something we haven't seen before. So that is a real new development coming out of the NSI regime. So in terms of red flags and key risks coming out of that, and the first one, and the one that's perhaps had the most publicity, is this risk of breaching the mandatory notification requirement. And in those circumstances, if that requirement is breached, the transaction completes without Secretary of State approval, then that transaction will be legally void, although it is possible to seek retrospective validation and to bring that back online after the event. So that possibility does remain, but from the outset, it would be legally void. In addition, any officer of an acquirer who consented to, when they collected, to prevent a breach of that mandatory notification requirement, they could face criminal prosecution, possibly including imprisonment, or a civil penalty of up to £10 million. And the acquirer, so the business itself that has completed in breach, could face a penalty of up to the higher of £10 million or 5% of worldwide turnover. And as is usually the case in these circumstances, that turnover isn't limited to the acquirer itself, but will include businesses owned or controlled by the acquirer. So there are serious sanctions arising from that breach. There is also the risk, a more far-reaching risk, that a transaction is reviewed under the NSI regime. If it is the case that that gives rise to national security risks, then that transaction could be subject to conditions. It may be the case that there are certain requirements imposed upon the transaction going forwards for it to continue, or it could be prohibited, or if it's already been completed, it can actually be ordered to be undone. So this is a regime that does have serious consequences, both for businesses and also potentially for individuals in the context of that mandatory notification requirement. I think there's been a real focus on the risks around this, and I think that when we are thinking about this regime, yes, there are risks, as with many things, but I think the thing is that these risks shouldn't put us on the too difficult pile. These are risks that can be thought through, they can be managed. And I think what we will find is that for the vast majority of transactions, they won't really be affected by the NSI regime. So it's there, it will apply to certain transactions. Some of the transactions will face difficulties, but I suspect that will be a minority of transactions. So I don't think we should think about this as something which should be impeding transactions. It's a known entity, there are risks, but I think as a positive, these risks can be thought through and they can be managed when planning transactions. So without further ado, what I would like to just quickly go through is a summary of what can actually be reviewed under the NSI regime. I think in this context, you can really see how broad it is in relation to its application. So when we're thinking about acquisitions involving entities capable of review under the regime are both planned and completed acquisitions of qualifying entities. And a qualifying entity would be a UK entity. I've here examples of companies, partnerships, trusts, but it would also be entities that are formed or recognised in law outside of the UK, where they have a link to the UK. And that is either they are formed outside the UK and they are carrying on activities in the UK, and or they are supplying goods or services in the UK. So they have a jurisdictional link to the UK, even though they may be a foreign domicile or foreign registered company. Just thinking that through a couple of examples. We have an example of the acquisition of a German partnership, and the partnership happens to have a branch office in the UK. Now that branch office would be sufficient for this to qualify as the acquisition of an entity carrying on activities in the UK by dint of that branch office, and therefore this acquisition would be within the scope of the NSI regime. Similarly, if we think about the acquisition of a US company, and in this context, the company is exporting to a UK customer, and what we see here, because we have a US company which is supplying goods in the UK, that establishes that jurisdictional link to the UK, and the acquisition would therefore be within the scope of the regime. I mentioned at the beginning this concept of corporate restructuring being caught. There is limited guidance on this at this point in time, but I think it is important that people have this in their minds when they are thinking about transactions. And that is the fact that acquisitions of qualifying entities, where they are within the same corporate group, could potentially be reviewed. So, for example, we have company A and company B who have the same ultimate owner. If company A acquires the shareholding of company B, the ultimate owner of A and B hasn't changed, but there has been a change in the chain of corporate ownership, and that in itself would be sufficient to potentially bring this within the scope of the Act. And it's also really important to flag as well that depending upon the circumstances of the transaction, that restructuring, reorganisation could trigger a mandatory notification requirement. So bear that in mind based upon the activities within your group. If there are things like a corporate restructure, although this perhaps doesn't seem to make the most sense when you kind of think about it, nevertheless, it is clear from the guidance that BEIS's position is that these sorts of restructuring activities could be caught by the mandatory notification requirements. That is always worth bearing in mind. So that's an overview in relation to acquisitions of entities. If we think then about acquisitions of assets, it's a similar picture. So it's both planned and completed acquisitions. And these are acquisitions of qualifying assets that could potentially be called. Qualifying assets, perhaps unsurprisingly, is broadly defined, and that would include land, that would include tangible, movable property, such as machinery, and that would also include ideas, information, or what's described as techniques with industrial, commercial, or economic value. And in the guidance, we see that being referred to as IP. I think actually when you break that basket down, what you see is there are things in there that would fall outside of what we would classify legally as IP. So it is a broad remit in terms of qualifying assets. So things that are in that last category perhaps covers a little bit more than you think. But as with qualifying entities, the qualifying assets require a connection with the UK to fall within the scope of the Act. So where we have acquisitions of land or tangible movable property, these can potentially be reviewed where the assets themselves are located in the UK, or if they're outside of the UK, we see that link whereby the assets are being used in connection with either activities that are carried on in the UK or the supply of goods or services in the UK. And in relation to acquisitions of IP, these could possibly be reviewed if that IP is again being used in connection with activities in the UK or the supply of goods or services in the UK. So there needs to still be that link jurisdiction with the UK for the regime to bite on this. And just by way of example, when thinking about assets outside of the UK, so if we're thinking about the planned acquisition of machinery located in Switzerland, and this is used to produce equipment which is then used in the UK, or we have the acquisition of assets of an offshore wind farm, and those assets are used to generate electricity, which is then supplied to customers in the UK. Because we have that link with the UK, notwithstanding the fact the assets outside of the UK, acquiring those assets would fall within the scope of the NSI regime. So it does have this broad jurisdictional reach, and transactions that perhaps at first blush you would think really have not much to do with the UK. I think when you dig a bit deeper, you would find more transactions than you perhaps think would have a sufficient nexus to the UK to be caught within the reach of the Act. So having thought about the sorts of transactions that can be reviewed, I think the next thing to touch upon is how can transactions be reviewed? And we touched upon the mandatory notification requirement. I mean, that in and of itself effectively assumes that national security risks are likely to arise both into the 17 areas. So that requirement means that the Secretary of State should be receiving notification, and that will then enable a review. So that's one way in, is the mandatory notification requirement. What about transactions that fall outside of that? Well, another possibility is that the parties themselves voluntarily decide to notify. So look at a transaction, they feel this is something they would like to get Secretary of State's view on, and they voluntarily notify. So that's another way in for the regime to apply and to review transactions. And then the last one, the catch-all, as it were, is that certain unnotified transactions can be called in for review by the Secretary of State. So if the parties themselves don't voluntarily inform the Secretary of State, there is the possibility of the Secretary of State calling in transactions and then reviewing them. So a number of ways that transactions within the ambit of the Act can then be reviewed under the Act. And the one I'd like to focus on first, perhaps unsurprisingly, is the mandatory notification requirement. And what we see here is that the requirement to make a mandatory notification, that is triggered if the acquirer is to acquire a certain level of control in a qualifying entity. So asset transactions fall straight away outside of the mandatory notification requirement. This is only in relation to qualifying entities. And that qualifying entity needs to undertake specific defined activities in the UK. And what we have from regulations, we have 17 high-risk areas and specific activities. I've called them notifiable activities for purposes of this presentation. And that is what it really turns on in terms of this notification requirement. As mentioned before, where this is applicable, the requirement imposes a standstill obligation. And that means that the acquirer must notify and obtain approval from the Secretary of State before completing that transaction. So I mentioned one factor there was control. I think it's worth us just seeing what is meant by control in the context of the mandatory notification requirement. And subject to limited exceptions, what we see here is that acquiring control of the qualifying entity means either acquiring a shareholding or equivalent if the business doesn't have shares in a qualifying entity of more than 25%, or acquiring voting rights in that qualifying entity of more than 25%, or acquiring the ability to pass or block resolutions that govern the affairs of the qualifying entity. If it is the case that acquisitions of lower levels of control are being made, those could still be reviewed, but they would fall outside of the mandatory notification requirement. So if you were to craft a transaction and you would be acquiring, say, 23% of a shareholding, yes, you'd be outside the mandatory requirement, but nevertheless, that could still potentially be reviewed by the Secretary of State. It doesn't take it outside the ambit of the regime itself. It just means it's moved outside the mandatory notification requirement. And thinking about the high-risk areas and the notifiable activities, so let's assume that we have the relevant level of control being satisfied by a transaction. The acquirer is going to take 100% shareholding in the target. Does that qualifying entity, does that target undertake any notifiable activities? And what the regulation has established is 17 areas of the UK economy that are deemed to be high risk. I won't read through them, but I think as you read through these on the screen, you'll pick up a flavour. These are not sort of general areas of the economy. They are quite specific, they are quite focused in terms of what they're covering. And I think you can instinctively see how national security concerns could arise just by reading the various category headings in those particular areas. As I mentioned before, the aspect around managed notification really hinges upon the notifiable activities. And we have these now set out in the notifiable acquisition regulations. And also we have guidance from BEIS, which summarises how the regulations will apply going forwards. I think what cannot be emphasised enough is that detail is absolutely critical. And what we have certainly found as external advisors is when we are thinking about these notifiable activities, we absolutely need input and expertise from the commercial and technical teams. And that may be at our client side, or that could be on the other side of the transaction, because without that in-depth knowledge of what's actually happening, what the activities are, who's doing what, where, how, etc., we as lawyers, we simply cannot advise upon what this all means. You need to have the right people giving the right steer on the application of the activities and what's actually going on. And just by way of example, I just picked out a couple of examples here. So we have the quite broad heading of cryptographic authentication, and what you'll find as you spend your time going through the various regulations is the headings can be quite broad, the activity is really quite specific. It may look at first blush as if something would fall in a category, then you realise the notifiable activities are defined quite narrowly, and therefore a lot of things perhaps fall outside of that. We're just focusing upon cryptographic authentication. So what we see here in terms of notifiable activities, these include where the qualifying entity is researching, developing or producing in the UK any product which has these various characteristics. There's a lot in that in terms of even things like research and development that may not be apparent from things like an IM. You may need to get quite into a team to work out, is that research and development activity going on? Does it cover these aspects? And that could take a bit of time to work through. So I think it is worth making sure that where you are making these assessments, you have the right people feeding into that process. And often when it comes to aspects like notifiable activities, that will not be lawyers, that will actually be commercial or technical people. Another point to flag is that within the regulations, there are a few anomalies. One that we've come across is by dint of how the definitions are actually structured, suppliers to emergency services, notifiable activities in that context that could trigger a managed notification would include the supply of fuel cards to a county council in Wales. Now, I don't for a moment think that's how the regulations are intended to function, but that is something that if you read them as black letter law, that is how they do apply. And I think it is worth just having in mind the clear steer you are having, the full overview of the activities of the qualifying entity. They do have some perhaps little niche businesses, little niche activities, just to understand what those are, so you have a full picture of what's going on and how that then potentially applies under the NSI regime. So as I mentioned before, when assessing risk, obviously we need to have a clear picture of the rights that have been acquired and the implications of these in relation to control. So we're hitting a control threshold that's going to pull us into the mandatory notification requirement. And again, as I've just touched upon, you really need to carefully consider the full extent of the target's activities and whether these constitute notifiable activities. And for some transactions, it's going to be really, really quick. You can just have a quick look, you've got the full picture, and you can say with confidence, no, there is not a requirement here to notify on a mandatory basis. You can rule that out straight away. For others, they will require more input and consideration. And I think it's really important to factor time in to complete that assessment. What you don't want to be doing is having to rush this 11th hour, someone's up to 3 in the morning trying to work out what's going on with this. You want to have a clear picture of this at an early stage, given that if there is a mandatory notification requirement, that is going to shape things like negotiations, but also timetable and how that moves forward as the transaction progresses. If it is the case that the requirement is triggered and the transaction then does proceed, detailed information will need to be gathered and submitted. That will also take time. I think that when this is described in the guidance, if you read it as someone who hasn't had to look at these forms, it seems like it's quite simple. Like it's not really a big deal to fill out a form. And if you've got all the information, as is ever the case, it is very simple. But quite often businesses just won't have the information in the form that's required. And that takes time, obviously, then to gather, to make sure it's accurate, to put it in the right format. That needs to be factored in. That's a transaction timetable. There is some good news though, and that means there's no fee payable. I'm not aware that there's been any talk of that changing at any point in the future. So that is a bit of a difference to say the UK merger control regime. So there is no fee payable if you are submitting a mandatory notification. And then outside of that particular area, transactions can generally be completed without obtaining Secretary of State approval. So if you're not required to notify and obtain clearance, general rule, you better complete as you wish. However, and there's always a but, certain transactions will be at greater risk of being called in if they are not approved by the Secretary of State. What voluntary notification does, it enables parties to confirm whether a transaction will be called in, and completion can then be conditional upon specific outcomes once that notification has gone in. So you can structure a transaction around a voluntary notification. What we also see outside of the mandatory notification requirement is that a broader range of transactions are capable of being notified voluntarily and also being called in. So this is kind of the fallback, this is the general wraparound we see here of the Secretary of State's powers to call in transactions and parties to notify voluntarily under the regime. And just to pick up on that point, so we looked before under the mandatory notification requirement of the idea of acquiring control in relation to a qualifying entity. So we know those thresholds. The new aspect here, I put in red, is this ability to exercise material influence. So if the acquirer is acquiring the ability to exercise what's known as material influence over the strategic direction of a qualifying entity, its ability to define and achieve its commercial objectives, that level of control would enable parties to notify voluntarily. It would also enable the Secretary of State to call in and review that transaction. So what does that mean in terms of material influence? Where's that come from? This is a concept which we see arising under the UK merger control regime, and the guidance issued by BEIS makes clear that it will, when it's thinking about material influence, it will apply the CMA's guidance in relation to merger control and material influence, and it will do so having in mind the NSI regime. So, okay, so what does that then mean? Well, the CMA guidance makes really clear that when you're thinking about material influence, because this is quite a nebulous concept, it is fact specific, it is case by case, it does require a holistic assessment of all the facts, but the guidance does give some general indications of where things are more or less likely to be problematic. So what the CMA guidance says is if you are acquiring a shareholding of between 15 to 25%, typically that is less likely to confer material influence. If you have a shareholding of less than 15%, that has rarely been found to confer material influence. And if all you are doing is acquiring as a minority shareholder nothing more than those rights that are normally accorded to minority shareholders, so for example, rights in the context of liquidation, then that is something where a situation of material influence is unlikely to arise. And some commentators have been referring to this as almost a safe harbor in the context of the NSI regime. If you can genuinely position yourself as a party who is minority shareholder, less than 15%, typical standard rights that are accorded to minority shareholders, that should then fall outside of the ambit of the NSI regime. So that, although it's not set in stone, that CMA guidance is helpful in thinking about voluntary notification and also the risk of call-in when you're outside of that mandatory notification requirement. In addition to qualifying entities, it's also possible for acquisitions of qualifying assets to be voluntarily notified or called in by the Secretary of State. And when we're thinking about control in relation to qualifying assets, that effectively means acquiring a right or an interest in or in relation to assets, whereby the acquirer is then able to use the assets or to do so to a greater extent than before the transaction, or the acquirer is able to direct or control the use of the assets, or again, to do so to a greater extent than before the transaction. Use of an asset for the purposes of the NSI regime includes exploitation, alteration, manipulation, disposal, or destruction. So again, we're seeing a really, really broad approach being taken here in terms of the sorts of asset transactions that could be looked at by the Secretary of State or could be notified voluntarily by the parties. And just to allow an example, I've included here a Japanese company that is funding a research project being conducted by a UK university. The company will receive a non-exclusive license, and that license will be to project-specific IP that is being used to further R&D by the UK university. The company is therefore acquiring the ability to control the use of IP. It's got that non-exclusive license. The IP is being used for activities in the UK, R&D being undertaken by a UK university, and therefore that transaction would be within the scope of the NSI regime. And that's something that I think on its face, you wouldn't think had anything to do with NSI. But in terms of the breadth of the application, when we think about qualifying assets, that is something that would fall within the scope of the regime. Now, whether that gives rise to national security concerns and should be voluntarily notified or be at risk of being called in, I think it's obviously a completely separate issue. But I think it's worth flagging that this broad approach to assets does mean that this would cover a range of different transactions and acquisitions that perhaps at first glance you wouldn't expect it necessarily to do so. So having thought a little bit about what can be called in, I'd like to now focus upon the call-in power. And as mentioned previously, unnotified transactions, they can be called in for review. That can happen post-completion. It can also happen while transactions are in progress or contemplation. So for example, if a deal has been publicised, it would in theory be possible for the Secretary of State to choose to call in that transaction. It will be called in for review if the Secretary of State reasonably suspects the transaction gives rise to national security risks. And for unnotified transactions that are completing on or after the 4th of January, when the regime entered into full force, what we see here is, well, in the first place, if it's an unnotified mandatory notification, these must be called in by the Secretary of State. The Secretary of State must do so within 6 months of becoming aware, and there is no long stop date to that. So mandatory is a sort of different kettle of fish, for want of a better expression. Other transactions, voluntary notifiable transactions, those can be called in, not must, can be called in within 6 months of the Secretary of State becoming aware. There is a long stop date to that power, and that is 5 years post completion. So whereas the mandatory that hasn't been notified, the Secretary of State must call that in. For other transactions that fall outside of that, the Secretary of State can call it in, has the option to call in those transactions. So when applying that calling power, what do we know about how this will be exercised? Well, what we have so far, we have a statement that's been published, and that really sets out in quite high level terms how the Secretary of State expects to exercise the calling power. And what is clear from that is that the assessment will be undertaken on a case-by-case basis, having regard to 3 categories of risk. The first is the target risk. And one of the key questions here for the Secretary of State is to think about whether the qualifying entities or assets are being used or could be used in a way that raises a risk to national security. The Secretary of State will also focus upon the acquirer risk. So is there anything about the acquirer in terms of its characteristics that suggests there may be a risk to national security? Does it have certain capabilities? Does it have certain links to entities known to be hostile to the UK? The acquirer risk will also be taken into account. What is also clear in the guidance, and I think again this should provide comfort to a good many organisations, is that there are characteristics of acquirers that, where they are long-term investors, they have a history of making passive investments, that this really should indicate low or no acquirer risk. So acquirer risk, again, case by case, but there are clearly certain types of acquirer that are already being acknowledged in the guidance as ones who should not give rise to concerns from a national security perspective. And the last factor that will be considered by the Secretary of State is the control risk, and a higher level of control may increase the level of risk that is seen to arise in the context of a given transaction. What is clear as well from the guidance is, although the Secretary of State would expect all three of these risks to be present when calling in a transaction, they don't all need to be. There's not a legal requirement to tick all of them. It could be that the target risk in and of itself is sufficient for a transaction to be called in, for example. The guidance also makes clear that there are certain types of transaction that are more likely to be called in. And perhaps unsurprisingly, those that are at higher risk of being called in are those that relate to notifiable activities. So we touched on earlier the possibility of structuring a transaction where you are acquiring a qualifying entity, undertaking notifiable activities to fall below a control threshold, 24% shareholding. If you're acquiring material influence over a qualifying entity, undertaking notifiable activities, that is more likely to be called in. So if that hasn't been notified voluntarily, although it's outside the mandatory requirement, that could then be called in by the Secretary of State, would be more likely to be called in by the Secretary of State. Where a party is acquiring control over a qualifying entity, which is undertaking activities that are closely related to notifiable activities, that is also more likely to be called in. There is ambiguity in the guidance around this particular concept. The guidance gives the example of activities that are related to transport, but not within the definition of transport. I think that's something that parties will need to consider in terms of how closely it's closely related. I think what is helpful, given that we are at an early stage in the regime, is that the ISU, in our experience, has been willing to give guidance on certain issues. And I think that this type of issue is one that it will be quite apt in terms of taking a steer if there are activities that could be closely related. How close is closely related? Acquiring control of qualifying assets that are or could be used in connection with notifiable activities or closely linked activities, or acquiring control over qualifying assets that are themselves sensitive sites or approximate to sensitive sites. So, for example, critical national infrastructure sites or government buildings. And in this context, the Secretary of State may opt to consider the actual or the intended use of land. So those types of transactions more likely to be called in. And the flip side of that would obviously then be transactions that are unlikely to be called in if the qualifying entity doesn't undertake notifiable activities or closely related activities, if the assets are not and could not be used in connection with notifiable activities or closely linked activities, and the assets are not sensitive sites and are not proximate to sensitive sites. So I think what that puts in play is, I think, quite a clear picture that where you take notifiable activities, particularly around entity acquisitions, and have those as a bit of a benchmark, the closer you get to those activities or activities of that description, the more at risk you are, I think, of being called in, and the more clear blue water you have between what the entity does and those activities, the less likely there is this risk arising of the transaction being called in by the Secretary of State. So what does all this mean? Well, at the moment, we see a picture where ISU is actively monitoring transactions, and where a transaction is likely to be called in, it may well be the party's preference is to notify voluntarily and then structure, as I said, that completion being conditional upon specific outcomes following that notification. For other transactions, voluntary notification may not be a perfect approach. It may be something whereby the risk is so low or the commercial timetable as such, it doesn't allow for notification and clearance, that this is not seen as a viable option. If it is the case that a voluntary notification is to be made, perhaps again, unsurprisingly, this will require detailed information to be gathered and submitted, and time again needs to be factored in to enable that preparation. The level of information is less than under a mandatory notification, but it's still a pretty substantial amount of data to gather together. And as I mentioned before, if businesses don't keep that data in that format as a matter of course, that will require resource to be allocated to enable that to be pulled together in the context of deal preparation. Again, no fee is payable. So as with the mandatory notification, with the voluntary notification, again, no fee is payable in that regard. What I think is helpful, and something that I know I'm certainly looking forward to, is that we're expecting guidance later this year, and that guidance is going to set out, based upon experience to date with the new regime, I think some factors for parties to consider when deciding whether or not to notify voluntarily. So I think there is, implicitly an acknowledgement that the guidance that's available perhaps isn't as fulsome as it could be, because we have a new dawn with the regime. There will be follow-up guidance to this during the course of this year, which should hopefully provide parties with additional parameters to have in mind when they're making that decision around voluntary notification. With that background in mind, I quickly wanted to touch upon what notification can mean for timing. And within this context, I think what we see as we go through this is, although there are references in guidance to time periods being 30 working days, there is actually quite a bit of room for extension around that. So if you are notifying a transaction, the route to notification, once you put the time in to prepare it, is it gets submitted online. The notification must be confirmed as accepted as complete. So if you send something that's incomplete, that's going to come back to you with an explanation as to what's missing, and you have to go and redo the work on that to get that to a state of being complete. So that must be confirmed as being complete and accepted. Once that happens, so from the date of acceptance, there is then a review period of 30 working days, up to 30 working days. And during that period, information may be requested. Where you would hope to land following that review period of 30 working days is no further action. So the green box on the left-hand side there, no further action. However, what is possible is that after that initial 30 working day review period, you may find that the transaction is called in for more detailed assessment. So the call-in notice issued by the Secretary of State. What the Secretary of State can also do at that point in time is put in place an interim order. And that interim order may impose certain restrictions, certain conditions that prevent preemptive action being taken. So what the Secretary of State does not want to have happen while the transaction is being looked at is for the parties to take certain steps that then negate whatever the decision is at the end of the investigation. So the Secretary of State is able to put in place an order which could require the parties to effectively hold themselves separate during that investigation period. When we think about the call-in investigation period, there is a further initial period of up to 30 working days for assessment. That is capable of extension. So if information is sought, if a meeting is requested, then that clock will stop. So that 30 working day period is not set in stone. It is capable of extension, and it can also be extended by a formal period of 45 further working days, which again, the clock on that will stop if information is requested, if meetings are requested, and if at the end of that additional period, the Secretary of State feels that more time is still required, then it's possible for further periods to be agreed with the parties consenting to that. And once you've been through that process of the call-in detailed assessment, then you would either end up hopefully within that green box, the final notification, no further action, good news, or the red box of a final order whereby the transaction will either be subject to conditions or potentially prohibited. So I think what we see from that is when you're notifying, that can result in relatively open-ended timelines, and those actions that result in that open-endedness are outside of the party's control. So that is something I think to bear in mind at the outset. And that then means that when you are thinking about conditionality, conditions of completion, timings, long stop dates, those need to be carefully thought through, having regard to where this could land in theory and making sure that those timings are captured in the transaction documents. And if something is taking longer than expected, that's either been sort of factored in so the deal can carry on, or that's been factored in and actually the deal's going to fall over because we didn't want it to take it longer than a certain period of time, and we've structured it in that way. I think just to think through those aspects. What's also important is, in addition to NSI and SI regime, is also addressing in the transaction documentation any relevant conditions and associated timings in relation to the UK merger control regime, and also any other applicable investment screening or merger control regimes. And just to touch briefly upon how the NSI Act interacts with UK merger control, what we see is that where a transaction could be reviewed, is capable of review under both the NSI and the UK merger control regimes. The ISU, InBays and the CMA will work closely to manage cases. However, I think there is a role for parties in that context. You don't assume that the authorities themselves will be working. I'm sure they will be, but don't assume that, and take an active role in that process in terms of engaging, in terms of updating, keeping that in train in terms of that assessment and being proactively involved. The CMA may also share confidential with ISU and Secretary of State to facilitate coordination where you have cases that are being investigated in parallel. And where we have a final order being made or a final notification being given under the Act, so we've gone through Secretary of State call-in, we've had that detailed assessment and a final order or a final notification has been given, then the Secretary of State is able to direct the CMA to take or not take such action under the merger control regime as the Secretary of State considers necessary and proportionate. So the Secretary of State can in fact trump the CMA, would be able to direct the CMA to say, we've reached this decision, there should be no investigation under the UK merger control regime. The Secretary of State will consult the CMA before issuing such a direction. But again, I think in that context, it's not something the parties should assume would necessarily be happening. I think you would want to try and actively involve yourself in any such process. So to close, before moving on to questions, just touching then at the end on risk management. So what should be borne in mind when planning transactions, whether as a buyer or as a seller? I think the first thing is to consider whether this transaction actually has sufficient links to the UK. Does it fall within the NSI regime? Don't assume it does necessarily. I think check that, check it does. And also if you're thinking about corporate restructuring, reorganisation, just have in mind NSI regime, could that be caught? It may not seem at first blush like it should be, but could it be as a matter of law? If it is the case that a transaction would fall within the scope, think about the rights being acquired and the implications of these in relation to that concept of control that we've discussed. But really importantly, dedicate appropriate resources and time, always critically time, to consider the full extent of qualifying entities' activities and all the uses of qualifying assets. With all this in mind, we're having gathered that big background information, would the Secretary of State be able to review this transaction? And if so, is that because it falls under the mandatory notification requirement, or is it the case that the Secretary of State could potentially call in this transaction? What is the risk of the transaction being adversely affected? So if it was reviewed, it was called in, at the end of a review under the NSI regime, what is the risk to this transaction? Would it still be standing? Would it have to be modified? What does that risk look like? Are there any other risks this faces? So again, into that mindset of NSI is not one-stop shop. Does it face any other risks under applicable regime? Would merger control in the UK bite upon this? What risk could it face in that context? And in view of all these risks, I think a really key question is the transaction still viable? Is that level of risk commercially acceptable? If it's not, then I think you have a steer in terms of where the transaction proceeds. But if that risk is acceptable, I think then thought that needs to go into considering the requirements or a strategy regarding notification if it's not a mandatory notification, And that could include, particularly for perhaps some transactions that would be seen as more problematic, possible PR campaigns, and not just focusing upon the legal aspects of this, but thinking about PR campaigns, whether you need to be perhaps having certain discussions, perhaps positioning the transaction a certain way, the good news story about the transaction, and also potentially engaging with both ISU and also the CMA to the extent relevant in the context of UK merger control. And I think really critically is ensuring that obviously conditions to completion have been properly thought through and are captured in those deal documents, and that the associated timelines, bearing in mind how open some of those aspects can be around the NSI regime, have been factored into the deal timetable. But I'm conscious we've cantered through a fair amount of content there in a relatively short period of time. But I'll take my screen off now, and if there are any questions, David,
yeah, we've
had maybe a few from you, Reggie.
We've had some questions coming in. One of the questions that has come in is about how early you can put in a voluntary notification in. I mean, for example, do you have to have legal commitment? Do you need to have exchanged?
That's a really good question, and we don't have 100% clear guidance on that. So what the guidance makes clear is that if the parties have heads of terms for a transaction, that is something which BEIS considers could then be sufficient to call in that transaction, to say Secretary of State would have jurisdiction to review, contemplate the transaction, there's your heads of terms, we want to put this in. I think the flip side of that then has to be, well, if that could be called in, that should also be capable of voluntary notification. So it's got to a point of contemplated transaction, heads of terms. I think based upon the guidance, heads of terms should be sufficient to go in and voluntarily notify. And that's not a million miles away from where the CMA is. The CMA has made clear that heads of terms, that would be sufficient to go and notify a transaction under UK merger control. So I don't think it's a stretch to apply that same view in the context of the NSI regime.
And you sort of talked about the parties sort of anticipating the risk of a mandatory notification and therefore might want to actually do a voluntary notification. I mean, is a voluntary notification likely to be quicker than a mandatory one?
We've seen nothing to suggest that would be the case. I think it also depends upon what you're notifying. So I think to say as a rule of thumb, you would always have a quicker route with a voluntary notification. I don't think that's the case. I think it will be a fact-specific assessment of transactions, and you could voluntarily notify something which may actually give rise to quite significant concerns around national security and could be subject to full assessment on the basis of the call-in notice, various questions resulting in the clock being stopped. So it could actually be that you have potentially some transactions that do take a long time to get an outcome on, even though they have been voluntarily notified.
And are the notifications confidential?
Yes. Yes, I think one thing that puts this in a different category to UK merger control. If parties have had experiences before, engagement with the CMA, they will know that where you have things, even things like initial enforcement orders, would be published. Certainly, you have a merger decision being published, which sets out full reasons behind the CMA's decision. The NSI Act, I think, by dint of what it's covering, is different in terms of publications. So even when you have a final order, for example, we wouldn't expect that to go into detail of the reasoning, setting out national security risks. You would have quite a concise summary of the transaction and the action being taken. If you're notifying something, certainly that notification would not be made public, and even steps around, so even having initial orders being put in place. Now, the guidance indicates that as a matter of course, those would not be published. So when we think about output from BEIS, from ISU around this, I think it's going to be a lot more limited than we see from the CMA and the UK merger control regime.
So the final decision though would be published, albeit that it would be a brief decision.
I think you'd be looking at a brief order, setting out parties, what the order actually meant, but in terms of the detailed substantive analysis, it wouldn't be something that you as a party in that sector could look at and say, well, that was the concern, that's exactly how they mapped it, that's how they worked it all through, we can apply that to our thinking. I think there'll be much more concern around the real information, and certainly any sensitive information would be removed from anything that's made public.
I mean, and talking of confidentiality, now, obviously, if it's a listed transaction or one that needs to be notified to a stock exchange, then it becomes a public transaction. But there's lots of transactions out there that are not true, not very public, or maybe entirely private. How's the Secretary of State going to know about them?
Yeah, that's a really good question. I think that where we have seen interactions around this is the ISU looking at what's been going on in the marketplace and picking up on press releases. What I think we will expect or can expect is that the ISU will have a team which is dedicated to looking at transactions. We know the CMA has its own mergers intelligence team. We know that the CMA actively monitors transactions. It may be the case that there is the possibility of information being exchanged between CMA and ISU in terms of market monitoring activities. It may be the case that ISU decides to build up its own know-how and approaches in that respect. But I think what we do know is there is market monitoring that's taking place. Quite what that looks like and quite what the numbers are in terms of bodies involved in that, we don't have visibility of at the moment.
So if it's a mandatory notification, it's a private transaction, it's going to be quite a big risk to take, isn't it? Crossing your fingers and hoping nobody's going to spot it.
I think that's right. I think particularly as well when you have no long stop date. So this could be something that sits in theory dormant in the background of companies' house documents for a decade, and then it is then flagged. We've seen, again, I keep drawing analogies to the UK merger control regime, but we've seen transactions that were kept quiet were then publicised, perhaps on the back of a report in a local paper. The CMA then looking at that years down the line. You could see a similar thing happening here. And if it has been the case that that mandatory requirement has deliberately been avoided and it's been deliberately suppressed, you can see then the possibility of some of the sanctions perhaps being applied, perhaps with a view to deterring that kind of activity.
But it could be a factor in deciding whether or not to make a voluntary notification. How public do you think this is going to be?
Yeah, I think that's right. I think it's something parties may wish to consider around how they position press releases. Are they inviting effectively a call-in by talking about certain activities? Could they perhaps play this in a slightly different way? And obviously, you would want to game that as a scenario in terms of worst case scenario. We get called in, this happens. We can then, if we have an interim order, we can run the acquired business. If we have to hold it separate in this way, we've got our bases covered. Therefore, it's a viable strategy to keep quiet, not notify, and wait and see. Because 5 years sounds like a long time, but it can fly by, particularly if other things crop up and perspectives change around particular areas. So I think that is something that it could be a viable strategy.
And I mean, although Sam, you've taken us very clearly through what the legislation says and what the guidance says and what you can draw from that and the analogies you can draw, the merger regime as well. But I know from talking to you on other transactions that it's not entirely clear when you read those regulations. And of course, we haven't had much caseload happening, have we? So are you able to approach the Secretary of State for guidance as to whether something is notifiable and how it should be approached and what the interpretation of the regulations are from their point of view?
Yeah, again, I think that's I think it's a really interesting facet of having a new regime, particularly one in which where you will have limited output from the authority. It may be the case that you don't really see the sorts of judicial challenges that necessarily set how the framework of legislation should be applied, where you have in other areas. So what we have found from our own experience is that ISU, where we are at this point in time with this new dawn, are willing to respond to requests to clarify certain aspects. So in recent transactions, we found a couple of points in the notifiable acquisition regulations where we couldn't quite work out what was the intention behind the drafting. And we then approached ISU and asked them if they could clarify how this was meant to operate. And it took about a week and a half, 2 weeks, but they did come back then with their perspective on how that should be interpreted, how this would apply. Now, obviously, that's not going to be binding, it's not got force of law, But I think it is helpful whereby if you then proceed on the basis of their interpretation, you have taken the time to then go and pursue and discuss with them and proceed on that basis. If anything comes out from that transaction, you at least have the comfort of, you've tried to play it by the book here. You've actually gone and sought to interpret this with them. This is where it's landed. This is what you did afterwards. So not legally binding, but I think helpful nevertheless at this point in time to have that access to ISU and to have the willingness to actually give a view on how those regulations should be applied.
Great. Well, Sam, thank you very much. I'm sure the audience and I certainly found that a really useful and comprehensive view as to firstly whether you need to worry about it and when you need to worry about it. But then if you do need to worry about what you need to do, and I'm sure everyone will find your slides really useful. I know we haven't got to all of the questions we received, and we'll be looking at those ones we haven't done afterwards. And as I said, the copy of this webinar will be available, so you'll be able to rewatch it at your leisure or indeed share it with your teams. So thank you very much. Thank you very much for joining us today, and look out for our invitations to the spring Think House. Thank you.
Thank you.